Ever wonder what happens in a DUI case when the scales of justice tilt unexpectedly? Today, we're discussing a case that shows how new laws and judicial discretion can lead to a surprisingly lenient outcome, even for impaired driving.
This is an interesting case. They come in all shapes and sizes. This is Cole Michael Kindig. The file is 252335. As far as I can tell, Mr. Kindig has no previous criminal record. I didn't see this.
No, they just.
Oh, well, good.
Mr. George
Okay, thank you.
gave it.
At any rate, the defendant is here with his lawyer, Mr. Tim George. This pre-sentence report was prepared by Daniel Frazan, who is on vacation. So he's not here, but he did prepare his report. Mr. George, what would you like me to know?
Thank you, Your Honor. I think it goes without saying in these types of cases, obviously, there's always an inherent danger whenever an individual makes the decision not only to drink or use controlled substances, but then get behind the wheel. And my client understands he's fortunate that he didn't hurt or injure or kill himself or somebody else. Just as an update in the report, he did report to me that he is a pipe fitter with Local 357.
Yes.
Sounds like he works different jobs, different hours. So he does have that type of employment going from him. As the court did indicate, he doesn't have any type of prior criminal history. He was pulled over for speeding in this matter. All reports that I have is that he was cooperative with the police. And in the investigation, I think the time that he did spend in custody was an eye opener for him. My client is young, and I think that in reviewing the report, he does realize that he was living a lifestyle that probably wasn't conducive to great choices. At the same time, Your Honor, he did plead to an impaired driving in this case. There's a relatively above the legal limit, but low blood alcohol content. There was not an accident. We would ask the court to consider whether fines and costs and time already served would be appropriate. In the alternative, if the court did feel that a supervised probation was appropriate, we'd ask the court to impose a 6-month probation that would allow him to get the Prime for Life, the victim impact panel, and some testing done. I believe that can be accomplished in 6 months rather than 12. Thank you.
Here, we've just heard from both the defense attorney and the village prosecutor, highlighted several mitigating factors for his client, Mr. Kindig. No prior criminal history, the fact he was cooperative with police, and crucially that there was no accident. He specifically requested the court consider fines, costs, and time already served, or at most a 6-month supervised probation. The prosecutor largely agreed, emphasizing the relatively low blood alcohol content and the lack of prior history or accident. She also suggested a period of probation, agreeing that 6 months might be more appropriate than 12. This earlier consensus on probation rather than significant jail time sets the stage for the judge's unique approach to sentencing.
Ms. Gish, this is a white pigeon case, and we get quite a few of these. White pigeon is at the intersection of US 12 and US 131. So there are two highways that go through there, and we get our share of cases. This one was going down US 12. But my recall, you were coming from Sturgis?
I was coming from Elkhart.
Elkhart. Ms. Gishwant, what's the village's perspective on this?
And the village believes that a period of probation would be appropriate. I do agree with Attorney George that maybe 6 months is more appropriate than 12. As previously indicated, the BAC was rather low. There was no prior criminal history, no accident, but I do believe a period of probation would be appropriate in this matter, just to make sure that at such a young age, he does not start down a bad path, keep him on the good path.
I'm certainly in favor of that. We do something called a timeout probation, where we give people a timeout from alcohol. Become somewhat desensitized to high blood alcohol levels. The next case we have was very high blood alcohol. He driving down 131 at a 247 in the middle of the afternoon. We've been seeing threes. One the other day was a 5-7, not driving, but she was taken to the hospital. The Auburn Hills case from 2023 says that district courts are supposed to sentence their defendants proportionally, and they didn't explain what that meant. Circuit court has a requirement of proportional sentencing, and they have the sentencing guidelines. The court does not have sentencing guidelines. We have our own that we use for drinking, driving offenses. And so proportionality means, I guess there's a spectrum of how people are to be sentenced. In addition, the Criminal Justice Reform Act implemented a presumption that there is no jail or probation in non-serious misdemeanors. And in the wisdom of the state legislature, drinking, driving cases where there is no accident is a non-serious misdemeanor. So I've been thinking about this case since last week. I think I first read this on Thursday afternoon. Proportional to what?
This is a pivotal moment in the case. The judge is grappling with the concept of proportionality in sentencing, especially for misdemeanors like this DUI. He cited a 2023 Auburn Hills case, which mandates district courts defendants proportionally. This principle requires a sentence to be proportionate to the seriousness of the offense and the offender. What's groundbreaking here is the judge's interpretation of recent legislative changes. He explicitly states that the Criminal Justice Reform Act impeded a presumption that there is no jail or probation in non-serious misdemeanors, and that drinking driving cases where there is no accident is a non-serious misdemeanor. This refers to reforms passed in Michigan, such as Public Act 169 of 2020 and other bills, which created a reputable presumption against jail or probation for certain non-serious misdemeanors, including OWIs without accident or injury. The judge is clearly indicating that the legislation has in effect placed this type of DUI at the very bottom of the proportion scale, limiting his options for a severe sentence. He acknowledges the inherent danger of drunk driving, but also the legislative mandate.
If this defendant is on the proportional scale, he's at the bottom. His blood alcohol was certainly over the legal limit. His PBT was 104, and the actual test came back at 0.96. Which is over the legal limit. But at the very low end of the cases we see, but that's where the desensitized part come in. You're good and drunk at 0.096, shouldn't be operating on a public roadway. You've got no traffic tickets, no criminal record whatsoever. As your lawyer indicated, you were polite and respectful to the officers. There was no bad driving. You were going 47 and a 35, which is very common right there. The only thing that troubles me is you were going all the way from Elkhart to Portage at this blood alcohol level. And as your lawyer and the prosecutor said, it's fortunate nobody else was hit or you didn't hit something. But in terms of proportionality, you're certainly at the bottom of the scale for 2026. And at the bottom of the scale for all of last year. They did give you an impaired. An impaired is given in, I think, a high percentage of the cases. And the legislature says this is a non-serious misdemeanor. So if I got to be proportional, somebody has to be at the bottom of the proportion. The fine is $300. There's a $75 crime victims' rights fee, a $50 state minimum fee, a $100 screening fee, $150 attorney fee, police reimbursement of $120. I'm going to order that you do the victim impact panel, which is $32. Let's add all that up. You got a PR bond, so I don't have any money to apply to this. But when they tell you drinking, driving is expensive, they're right. You've got a good job, so you have the ability to pay this. But 300 plus 125 plus 100 plus 150 plus 120 plus 32 is $827. That's as low as it gets. Let me add this again. 300 plus 125 plus 100 screening fee plus $150 attorney fee, $120 police reimbursement, good for White Pigeon for including it, $32, $827. You are to attend the victim impact panel within 6 months. I'm not going to put you on a probation, and I'm not going to order any additional jail time. For many, many years, Judge McManus had a theory that everyone should spend 1 day drunk and 1 day sober. So everybody that got convicted of drinking, driving spent at least 2 days in jail. But you can't do that anymore. There's some logic in it. You got arrested on the 16th and you bonded on the 17th. So we'll call it 1 day jail credit, 1 day, $827 within 6 months. I'm gonna send you out to the court for the victim impact referral. Mr. Kindig, you're the first person in this year that hasn't received a jail sentence as part of their sentence. And I hope what happened already is enough.
The judge has just delivered a strikingly lenient sentence for a DUI. Cole Michael Kindig received a fine totaling $827, which includes a $300 fine, criminal victim rights fee, state minimum fee, screening fee, attorney fee, police reimbursement, and a victim impact panel. Crucially, he received only 1 day for jail credit for time already served with no additional jail time and no probation. The judge explicitly states that Kindig is the first person in the year that hasn't received a jail sentence. He directly contrasts this with previous judicial philosophy like Judge McManus' theory of a minimum of 2 days of jail for all drunk driving convictions, explaining that such a practice, you can't do that anymore. This decision is a direct application of proportionality principle and the Criminal Justice Reform Act discussed earlier. By categorizing this specific DUI offense, one with a relatively low BAC, no prior record, no accident, and cooperative defendant, as a non-serious misdemeanor under the new framework, the judge felt legally constrained to impose a sentence that at the lowest end of the spectrum, focusing on financial penalties and education rather than incarceration or supervision. It's a clear example of how legislation changes can fundamentally alter judicial outcomes, even for offenses traditionally viewed harshly by the public.
A high percentage of people that get arrested for drunk driving never come back. It's expensive, it's embarrassing, it's humiliating. And so I don't ever want to do that again. I'm hoping that you're in that percentage. There's another percentage that come back over and over again, and they take up a lot of our time and effort. So hopefully this is enough to make you realize you can't try to get from Elkhart to Kalamazoo after drinking a bunch of alcohol. There's a high likelihood that an accident may have occurred. We'll never know. You can also do the victim impact in Kalamazoo. I'd rather you did it here. Give you an envelope regarding the fine. You can pay with a credit card. You can send in payments, pay it all at once in green cash. But today is March 2nd by 8/2/26. All right, I'll give you that. As I indicated, all the factors, no prior criminal record, no prior traffic record, relatively low blood alcohol level, no accident, polite, cooperative with the officers, and no significant bad driving other than speeding, all led to this. All right, you take this out to the counter and they'll give you some information about the victim impact panel when it is. Thank you, Ms. Geschwitz. Nice to see you. It was a nice day for a drive, but do you have any other business down here?
No.
Or you get a trip to Yoder's before you go back, and then I'll see you next time.
All right, sounds good. Thank you, Judge.
In this specific case, Cole Michael was sentenced on March 2nd, 2026 in St. Joseph County, Michigan. The judge ordered him to pay a total of $827 in fines and fees, attend a victim impact panel within 6 months, and credited him for 1 day of jail time already served. Crucially, no additional jail time or probation was imposed. This outcome reflects the judge's interpretation and application of Michigan's criminal justice reform efforts, which, for non-serious misdemeanors like impaired driving without an accident, create a presumption against jail or probation, steering sentencing towards rehabilitation and financial penalties rather than incarceration. There are no public records indicating further appeals or post-sentencing legal issues for Mr. Cole related to this particular incident. This case serves as a powerful illustration of how evolving legal frameworks can influence sentencing and challenge traditional public perceptions of justice.